restriction on state's power. Every decision, my lord, of constitutional morality, whether it is Navtej, whether it is Sabrimala, are all decisions, my lord, pro-choice. Kindly make a note, my lord, they are not anti-choice. Today, what the state is saying is that use constitutional morality to defeat choice. That is not the jurisprudence. Constitutional morality, my lords, is pro-choice. Access to institutions, my lord. Access
It's
to
a restriction on
temples.
state power. It's a restriction on state power. Yes.
Yes, my lord. I'm grateful for that, my lord.
Agree.
Then, my lords, a lot of arguments have been made on possibility, my lord, of abuse. That if we do this, then somebody else will do this. A Brahmin boy will turn up. Somebody will turn up with something else. I say, my lord, in constitutional adjudication, we cannot decide on hypothesis. Your lordships will have to decide on the facts. And I will only cite, my lord, that 1983, just give me volume 1 SEC, page 147, my lord, this is Sanjeeva Coke. And just mark the paragraph numbers, my lord. Paragraph 11.
You have not given in this right compilation.
No, my lord, it's not there. We judges are not authorized to make disembodied pronouncement on serious and cloudy issues of constitutional policy without the battle lines being properly, lordships are aware of this, my lord. Then, my lords, some submissions have been made, my lord, on other jurisdictions. And I have to point that out. Mr. Puvaya, my lords, made some submissions on other jurisdictions. And he cited, my lord, European court decisions, etc. Lordships may only make a note. As far as Mr. Puvaya's submissions are concerned, he's handed over a written submission. At page 20, at page, my lord, 21, he has cited, my lord, at page 14, in fact, he has cited a European court decision from Turkey. And he says, my lord, that headscarf ban was upheld. Now, kindly see, this is a decision, my lord. And subsequently, this decision, my lord, has been overruled. And that decision, my lord, my learned friend will hand over. My lords, of the Turkey Constitutional Court, they have reversed that headscarf ban. My lord, that decision, my lord, my learned friend will just hand over of the Turkish Constitutional Court. My lords, one more point which I want to make. Some of the councils have said, my lord, that this is against international practice. And my lord, it was never my case that this is against international practice, etc. Because that submission was made, I have to rebut that. My lord, there is a parliamentary enactment called the Commission for Protection of Child Rights Act 2005. And if I can just hand over that compilation, that act is there, I will not read it. Shaul, if you can just hand over to the Honorable Court. That act, my lord, talks about rights of children. And the rights of children is defined by Parliament to mean, my lord, the same rights as is granted, my lord, in the Convention of the Rights of Child. And the Convention of the Rights of Child, which is, my lords, ratified by 196 countries, including India, expressly and incorporated into municipal legislation, expressly recognizes headscarves. So, my lord, let us, lords, that's what, my lord, the point I'm making. Just have a look at, my lord, I'm not going to, just have a look at volume 4. And just have a look at, my lord, article 4, first the section, our parliamentary act, page 47 is that act. And this I am not citing as any new point. This is only in response to say that this is a regressive practice. I am showing that this is not a regressive practice. Wearing a headscarf is only a display of diversity. Just have a look at, my lord, the act. It starts at page 47. At page 50, my lord, is the child rights definition. That is section
You were mentioning
2B.
about Turkish judgment overruling the other earlier
Yes.
view. What
Yes,
difference
yes.
it makes to us? We have been following
Not
Denny, even when his
I-
judgments are reversed by the House of Lords.
Yes, my lord.
What
No
difference it
difficulty.
makes?
No difficulty, my lord. Since judgments have been cited at the bar, it's my duty as an officer of the court to point out that overruled
All right,
judgments
all
have been cited. That's all.
All right.
Yes, my
Thank
lord.
you. So far,
No, my
so
lord,
far as
just-
recognition of hijab is concerned, nobody is denying that hijab is not a recognized headdress.
No, my
Hijab
lords,
is
what
a
has been argued?
recognized
No, my lords,
headdress.
kindly see. No, my lords, kindly see what has been argued is that it is a regressive practice. It has been argued, my lord, by my learned friends. It is against constitutional morality. We are living in a society which should not be, there should be uniformity. And therefore, no religious display should be shown. Why should a girl be covered with a headscarf? That arguments have been made. In response to that, I
That
am
is
saying,
with
my lord,
respect to
all of-
dignity.
yes,
That is with respect to dignity. It was argued.
that's right, my lord. That's
It
right.
was not that it in any manner.
No, my lord, I
against
just want to
morality.
point that out. And my lords, the other jurisdiction which was cited was France. And lordships, I have given the convention. France and Turkey, my lord, are the exceptions to this convention on child rights. France and Turkey, my lord. Lordships may make a note, and that's there in the compilation.
All
Then, my
right.
lord, lords, lastly I want to say is this: that what is the net result, my lord? The net result is today people who want headscarves, my lord, or who want a turban, Sikhs, are being denied on the pretext, my lord, of the geo. What is eventually happening, my lord, is that their right to education, which is paramount and an overarching principle, is being, my lord, put on the back burner.
Yes.
And I say, my lord, as a state, you should facilitate. You should create an enabling, my lord's atmosphere in which that right can be exercised. Because lordships will just make a note in
You said
2012, my lord.
positive secularism. You mentioned that judgment.
Yes, my lord.
Positive
I am on right to education. No, my lords, I am on right to education. 2012, 6 SCC, page 1. Supreme Court Justice, Chief Justice Kapadia's judgment, clearly in paragraph 32, my lords.
Tell the name of
says-
the judgment. Tell the name of the judgment.
Yes,
We've been
yes,
doing
my lord.
also.
I'll just give that. 2012, 6 SCC. Society for Unaided, my lords.
What is
Schools.
under the Right to Education Act?
Yes, my lords, that's the constitutionality was challenged, lordships will recall. Yes, my lord, in that context, they examined the right to education and they said, my lord, that it is a part of Article 25. Just have a look at that, my lord. By judicial decisions, right to education has been read into right to life under Article 21. So a state's decision, my lord, let's say even the rule, if it is eventually leading to a situation where people, my lord, are not going to have the full benefit of the state's policy education, I say, my lord, it is challengeable under 21 as well. And lastly, I say, my lords, on ERP, my lords, we had cited, my lords, surahs from the Quran to say, my lord, that this is an essential religious practice. The learned AG, my lord, has said, look here, this is Quran.com, and we can't go by.
First clear your stand as to whether you want to say that it is an essential religious practice,
Yes, my lord.
or
Lords,
whether you want to say that in order to attract Article 25, it is not necessary to see whether it is part of essential religious practice or not.
Lords, I am going to put it on two folds. One, my lord, is that I say it is an essential religious practice. There is no doubt about it. But what I'm also saying is that there is no restriction in the first place. There is no government order. According to me, the government order which puts that restriction, my lord, is totally illegal. My lord, in the absence of a valid restriction, my lords, for the court to get into, my lords, this arena of ERP is strictly not necessary. But if your lordships were to do it, I say, my lord, it is an essential religious practice. I have cited, my lord, Quran.com, and my lords may just have Quran.com is not a translation, my lord. My learned friend is wrong on that. I have given copies of the Quran.com website. It is a compilation, my lord, of various translation of all authors, including Yusuf Ali. Just Shaul, if you can just hand over that.
Authenticity of that.
Yes, that is why I want to show, my lord.
Court in the country has treated it as authoritative text,
Yes, my lord. Just have a
authoritative
look at,
version of Islamic law.
yes, my lord. Just have a look at why I wanted to point out. Just have a look at this is the exact of Quran.com, and the relevant surah is, my lord, 24. And this has all the authors, Abdul Halim, different translation, Pickett Hall, over the page, Yusuf Ali, which my learned friend relied upon, and which I have also quoted in my petition. So therefore, my lord, it is not an unauthorized translation. It is a compendium of translations of all reputed authors. And what I say, my lord, is that the verses in the Quran clearly say, I have
Where
cited
it
that in
says.
my opening.
Where it says.
Kindly see, my lord, the first one. Just see, my lords, that item 1.
Yes.
And tell believing women that they should lower their glances, guard their private parts, and not display their charms beyond what to reveal. They should let their headscarves fall to cover their necklines. Now, my lord, the Arabic word is khimar, and khimar, my lord, is translated, my lord, as a
Khimar
as a
is not
veil.
hijab.
Yes, my lord. It's
Khimar
it's
is not hijab.
Yes, my lord. Khimar is a veil. My lord, it is like a ghungat, which, my lords, people wear. Now, lordships can translate it as in English, my lord, it can be a veil. But a ghungat, my lord, falls on the head and then it comes, my lord, on the shoulders. Huh? Yeah. My lords, the second source. And my lord, just make a note. Justice Kurian Joseph in paragraph 7 of Shaira Banu, which is the deciding judgment, clearly says that what is in the Quran has to be followed, and that is a part of Shariat. That is, my lords, paragraph 7 of Justice Kurian's judgment, 2017, 9 SCC, page 1. My lords, the second source of Islamic law is the Hadith. And Hadith, my lord, is also the first source, is not a second degree. That your lordships will see Justice Nariman's judgment in paragraph 54 in Shaira Banu. Just make a note, my lord, that Hadith is as authoritative as the Quran itself. And the Hadith I have handed over to your lordships. Yeah. Come on. My lords, that is it's a collection by Sahih al-Bukhari of the Hadiths, my lord. And this is yes, it's mentioned in my writ petition.
Sahih Bukhari.
Yes, Sahih Bukhari. I'm sorry, sir, I'm not well conversant, so please pardon if I have.
Sahih Bukhari.
Bukhari is the name of the author.
Right.
Yes.
I'm told, my lord, Sahih is correct and Bukhari is the name of the author. But just turn to the last page of that, my lord. The Hadith stands on the same footing as the Quran, as per para 54 of Justice Nariman's judgment in Shaira Banu. And there can't be any dispute, my lord, as far as this is concerned, as far as what is the importance to be given to Hadith. Now, please see page 2, the last page here, chapter 12, verse 24-31 is explained.
How it was practiced.
And how it is practiced. Narrated Aisha, may Allah bestow his mercy on the early immigrant women when Allah revealed and to draw their veils all over their Juyu Bihinna, their bodies, kindly see, my lord, their faces, necks and bosom, they tore their murut, woolen dresses or waist binding, clothes or apparels, and covered their heads. This is what I'm saying, my lord. This is the practice which is, my lord, the first degree of source for Islamic law. And there is no dispute, my lord, as far as this hadith is concerned at all. And my lord, lordships are aware, my lord, Aisha is the wife of the Prophet. And my lord, lastly, none of the councils, my lord, appearing on the other side, have disputed two judgments of the Kerala High Court, single judge, division bench, and also Madras High Court, my lord, which has gone through, my lords, these Islamic verses, scriptures, and has come to a conclusion that parda or a burqa may not be an essential practice, but a headscarf is. And my lord, my learned friends have not cited a single decision of any court in the country, my lords, saying that headscarf is not. And I have cited, my lord, a minimum of 3 decisions of Indian courts, which, my lord, categorically say that headscarf is a part, essential part of Islamic religion. My lord, so therefore, my lord, I respectfully submit that, my lord, therefore I respectfully submit, my lord, that the GO, which is the basis for our action before your lordships, is totally illegal. There is no restriction, legal restriction, my lord, for exercise of Article 25(1). And I am sure, my lord, lords, I am reminded, my lord, to end with what, my lord, Dr. Ambedkar said, my lord, when he actually finished, my lord, drafting the constitution along with the other lords, fathers of our constitution, and he made a speech, lordships are aware. He said, my lord, we may have a great constitution, but the people who implement it are bad, my lord. It will turn out to be a bad constitution. And I dare say, my lords, the way the state has implemented this, a good constitution, my lord, has been totally frustrated. But I am equally sure, my lord, that we are in the hands of a constitutional court, my lord, and we will make our constitution work. And I'm sure, my lord, that justice will prevail. I'm grateful for a very patient hearing, my lord. Lordships are sitting till 5. I am really grateful, my lord.
That seal cover process from it.
Yes, please. Yes, please.
May I, my lord,
They made 3 sets.
my lord, may I just say, may I, my lord, seek your lordship indulgence, my lord?
Oh.
I am appearing in 3088.
They may be given to chief.
Yes.
My lord, I am 30 person. Tomorrow is Jumma. Kindly.
So it contains some material note which is in the part of progress of investigation. Right?
No, therefore we also don't want to see. Only under the chief.
But lordships can see. I have no problem. For a moment, we had in fact made 3 sets.
Give
I made 3 sets, but now that lordships say
Give one copy.
Yes.
Give one copy. We will see. And we will return it to you, noting the content. Now we will continue tomorrow. Whatever the remaining counsel for petitioner want to say in rejoinder, they may make their submission. We will assemble again at 2:30.
Your lordship.
And tomorrow we will finish up with the arguments part. And we will
Please, Your
request
Lordship.
all of you to prepare your written submission and file, submit it to the court within 2-3 days.
Lords, I have already given one. Any
I'm-
additional, my lords, points which I have covered in the rejoinder, I'll give a supplemental written submission.
You have already filed the.
Yes, but my
written
rejoinder
submission.
submissions also, I'll put it in a written note so that your lordships
Yes,
are
yes, you give
benefited.
it whatever you want, you give it.
Yes, yes.
I am at your lordship's beck and call anytime, my lord, your lordship can.
Give it in the chat.
Never mind. I'm at your lordship's beck and call.
Seal it.
My lords, tomorrow is Jumma. Kindly pass an interim relief that Jumma, hijab can be allowed on Jumma Fridays. Your lordship had assured me that.
Where we have assured.
In respect of 2146.
You had told I will consider your prayer. Your lordship had categorically stated last week by Lord.
We'll continue tomorrow.
Grateful.
Note-
Lord.
note
I'm
of
highly
the
obliged.
Submission of various name of the advocates and say that put up tomorrow at 2:30.
Please, Lord.